Good morning, sir. Good morning, sir. Please confirm if I am audible, sir. Good morning, sir. Can we get started?
Yes, ma'am. Yes, ma'am. We can.
Very good morning, dear students. Welcome to the first session on your academics for business laws by our very own and renowned faculty, Raj Ganesh sir. Now, Raj Ganesh sir needs no introduction, but as a formal introduction, let me introduce Professor Raj Ganesh sir to you. Professor Raj Ganesh sir has been teaching CA and CA students for the past several years in Trisha Group of institutions. Sir is favorite among the law community students. Sir has authored also several books for the CA and CA students, and he is a founder of the institution called Lake Pearl. This is about Raj Ganesh sir for you. Over to you, sir.
Video. Good morning, students. Please make sure if you can hear me clearly.
Sir, you
Am I
are
audible?
audible, sir. Sir, you are audible.
Yes. Thank you. Good morning, dear students. So if you can hear me, please give me a reply in your YouTube live chat, please, please. Yes, my dear students, I can see around 36 students are online. Please give me a reply. Good morning. Good morning. Yes. Neha, Omkar, Srijana, someone is finding the solitude. Very nice. Good morning to nice to see you all. Yes. If you could tell your friends and join more students here, it will be much better. Please inform all your students that we are live now so that many more students can join and take the benefit of the session, right? So, how is your preparations going on? CA Foundation exam dates are on. How's your preparations? Yes, good morning. I'm doing well. I'm doing well. Thank you. Yes. So, how are your preparations going on? Okay, my dears. So, in today's session, as we all know, very important provision with respect to a CA Foundation law paper is Contract Act. So, what we are going to do in the today's session is we are going to discuss about Contract Act in detail. Of course, this is going to be a marathon session. You know this, how it is going to work out. So let me brief you on how exactly we are planning for this session and what is our what we are supposed to how we are supposed to participate in the class. So to start with, uh, my today's session, that is morning session as well as evening session. Today we have two sessions, one in the morning and one in the evening. Morning one will go up to 8 o'clock. Sorry, 8:30, and give me 1 second. Morning one will go up to 8:30, and then evening session will start at 6 and will go up to 8 o'clock. So in both these sessions, my target will be to complete the provisions of Contract Act. Of course, I'm not going to touch all the provisions. Those provisions which I'm going to do today will be very, very important provisions with respect to examination perspective. We can expect majority of the questions from these areas. We can see repeated questions in many of the examinations. So what I'm going to do is I'll brief you out each and every sections which are very important for us. And through that, we'll also discuss what type of questions we can expect from those sections, how to answer them if a question is asked. So this will be our area of focus in this particular session today. So to start with, I have taken up certain important areas as you can see in the notes given here. So each and every sections keywords will be written on the screen, which you can note down, and same will be made available to every student. This PDF will be shared with you so that you can also read this if at all at the time whenever it is required for the examination preparations. So the strategy is going to be very simple. Recall and revise. We are not going to stick to any books. Rather, we are going to purely recall it based on our memory power. Yes. So to start with, the first and foremost very important provision under the Contract Act is the definition of contract. So if you can tell me, if you can please respond, which section tells us? Please tell me the section number, my dears. If you can recall the section, what is the definition of contract? In which section can you find definition of contract? Yes, my dears, I'm waiting for your response. So let us make this an interactive session. So more and more you participate, the session is going to be more fun. So please do participate. So which section, sir? Section 2 clause H of the contract. Very nice, very nice. Many of you are responding here. That's nice to see. So section 2 clause H. Section 2 clause H tells us about contract. So what is contract? Very nice, very nice. 2 clause H, contract. So there are two factors here, agreement. There are two factors here, agreement and enforceability. So agreement and enforceability, this is basic thing everybody knows. So what next we need to see is, what do we mean by agreement? Agreement is a result of two important factors. One is offer or proposal, the other one is acceptance. Offer or proposal is defined in section 2 clause A and acceptance is defined in section 2 clause B. Very important definitions. You cannot miss out these definitions. Offer, person signifies willingness. This is the keyword, correct? When a person signifies his willingness to do or abstain from doing anything. Plus, not only that, with a view of obtaining assent. With a view of obtaining the assent, right? So this is the significance, or this is what we are going to see about the offer. See, whenever I tell a particular provision, wherever you are, sorry, at any place, wherever you are, please make sure that you recall the subject. You will be telling these loudly. Don't worry who are there around and all. You just focus on recalling the provisions on your own so that you will understand which provision is very clear to you and which provision is not very clear. So that is why please make sure that you keep it very open and you keep the session very interactive. Yes. So offer or proposal. That is first thing, offer or proposal. Second thing is acceptance. That means one person makes the offer. One person makes the offer and the other person accepts it. What is acceptance? The person to whom the offer is made. The person to whom the offer is made signifies his acceptance. The person to whom the offer is made signifies his acceptance. I'll call it as acceptance or his assent. The word used is assent, not the acceptance. The word used is assent. His assent there too. He said to have accepted. So this is with respect to acceptance part. So offer plus acceptance. When the proposal meets acceptance, I'll call it as promise. Offer or proposal when accepted. Proposal when accepted becomes promise. Proposal when accepted becomes promise. So this is the next thing. Proposal when accepted becomes a promise. This is what the final factor is there. So with this, we understood the basic part of offer and acceptance. Of course, I'll tell you what type of questions we can expect from these definitions as we discuss the essential elements. I'll go further. So now when it becomes promise, the next factor comes into picture, that is agreement. What do you mean by agreement? So can anyone tell me, or can you recall, what do you mean by agreement? What is the definition of agreement? So agreement simply says promise, set of promise. Promise and set of promise forming consideration to each other. Promise and set of promise forming consideration to each other is called as agreement. Now, all agreements are not contracts. There are few agreements which cannot be considered as contracts. Some agreements may be void ab initio. Some agreements may be illegal. Some agreements, though legal, fails to get enforced in the court of law. Or some agreements don't have the power of creating legal relationship. So, keeping this point in mind, we should analyze when will an agreement be enforceable by law? When will you say an agreement is enforceable by law? It is an important thing to understand. When will you say an agreement is enforceable by law? For which, very important section to be kept in mind is section 10. Section 10 tells us enforceability. What are the essential elements to say an agreement is enforceable by law? So that is what is said in section 10. So in section 10, there are two divisions. Of course, when we discuss this particular part of enforceability, we discuss it in two different headings. One general principle, one section 10 principles. In general principles, we normally say there should be two parties, fulfillment of legal formalities, then possibility of performance, certainty of meaning, all those factors will come there. Coming to the section 10 part, very importantly, section 10 part is very important there. There are 6 different components. There are 6 different components to say an agreement is valid, correct? There are 6 different components. So which are the components that are very essential here? One by one we need to see here. Section 10 requirements for an agreement to be valid contract. For an agreement to be valid contract. First one is there should be an agreement. Definition wise, we have seen what is agreement, sir. But when it comes to section 10, there can be a very important question. Question answer analysis ಮಾಡಬೇಕಿದೆ. If I have to tell you what type of questions can we expect here? Sir, normally they'll keep the questions sometimes based on social agreement. Social agreement. Maybe a person invites the other person to attend a movie, and one person doesn't attend the movie. Can the other person sue? Can the action can be taken? Will it be a valid contract? This type of questions will be asked by the institute. Or second type of questions they can ask, the birthday party question. In the last attempt they had asked. If you see the question paper of last attempt, you could have seen this particular question asked. A lady invites her friends for the birthday party. Later on, friends don't turn up. Will it form a valid contract? Can she enforce the contract? This was the question asked. And the answer was very simple. It was based on this particular social agreement concept. Social agreements are not contracts. Social agreements that normally happens between friends. Normally that happens between people who know each other, where parties don't have any intention to create legal relationship. Where parties do not intend to create legal relationship, it will not be considered as contract. Though it is an agreement, it is just a social agreement. It is not a contract. Then second one is domestic arrangement. Domestic arrangement. So domestic arrangement wise, when we discuss, Very important case law to be kept in mind is Balfour versus Balfour. You remember Balfour versus Balfour? Balfour versus Balfour. What happens in case of Balfour versus Balfour? See, sometimes the facts of the question will be like this. A husband enters into contract with his wife to pay monthly maintenance. Maybe he's going on some job to some country, or maybe he's going out, or maybe he promises his wife that he'll pay monthly maintenance. Later on, he denies to pay the monthly maintenance. Can this contract be enforced? At that time, you should be answering the provisions with the help of this Balfour versus Balfour. They will twist the question like this at times. The question can be twisted. They'll say, due to frequent quarrel between husband and wife, husband promises to stay apart from his wife and promises to pay monthly maintenance to his wife. See, remember this. When husband is quoting this actually comes in your no consideration, no contract part, where natural love and affection, other factors are there. So there, the question is going to be very different. I'll discuss it when it comes to section 25 detailedly. What are the possibilities? So don't relate that particular case to this, because there, natural love and affection, there are some other conditions. This is simply payment of maintenance, where a husband promises to pay monthly maintenance to his wife. There is no intention to create any legal relationship. You will go with Balfour versus Balfour and you will answer the question. So this is one possible question here. So in agreement, this part is very important. In your ICA material also, you can find this agreement part, side heading, and other factors are there. You should pay a close attention that you read that particular text very clearly. Any questions can be asked from this area. So that is the first thing. All other factors we have detailed discussion: pre-consent, capacity of the parties, lawful consideration, legal object, not expressly declared as void. All these are elaborated in various other provisions of the law. So second one, I'll say here, second important factor for a contract to be valid, for an agreement to be enforceable by law, is nothing but capacity of the parties. Capacity of the parties is discussed under which section? Capacity of the parties is discussed under which section? It is discussed under section 11. You can find the particular provision in section 11. You can find the provision in section 11. Yes. Third one, pre-consent. Provisions regarding pre-consent starts from section 13. Section 12 comes with respect to capacity of the parties only. It tells us the definition of sound mind. I'm just recalling the provisions here. My dears, please do be recalling along with me. Yes, don't miss out any sections. Section numbers are very important, and writing the correct section number and correct content becomes very important. You cannot misrelate the sections. Yes. So please, I can find Anil is responding. Very nice. Some more people I want you to respond in the online session. Please do respond. I'm checking out your chat box in the YouTube. Make sure that you respond with section numbers. Whenever you come across the section numbers, you have to reply. So please do be replying here. Yes. So pre-consent. Pre-consent is a combination of various sections: 13, 14, 15, 16, 17, 18, 20, 21, 22, and 19 and 19A. These are the sections which relates to pre-consent. See, what I'm doing is I'm dividing the sections for you, sir. I'm dividing the sections into cluster so that you pick up a particular area and try to remember the sections of that area. Things becomes much simpler for you to revise. If you see here, when I say agreement, agreement requires no section. Of course, the definition of agreement is there. No other sections are essential. So you can simply relate to these two things. Whenever it comes to agreement, you should remember that social agreement, domestic agreement are not enforceable. Second thing, capacity of the parties. You remember section 11, section 12. Section 11 tells us capable parties. Section 12 tells us what is the definition of sound mind. Then comes free consent, full cluster. Consent 13, free consent 14, coercion 15, undue influence 16, fraud 17, misrepresentation 18, 20, 21, 22 speaks about mistake, and 19 and 19A, effect of coercion, fraud, misrepresentation, and coercion, effect of undue influence. One cluster, very important cluster. You cannot miss out. We can expect at least one question from this cluster, for sure. It may be based on coercion, it may be based on undue influence, it may be based on fraud. Any one question will come. Very important, especially those 19 and 19A forms a very important sections here. 19 and 19A, you should be very thorough with the wordings of 19 and 19A. What will be the effect when a contract is entered and there is no pre-consent, there is no concept of pre-consent. Very, very important. Please pay attention. Yes. Going on further, point number 4, what do we have? After pre-consent, we go for legality of the object and lawful consideration. Before that, I'll write the point as consideration. Consideration point is discussed. Consideration is discussed where? So consideration is discussed under section 25. Section 25 simply says no consideration, no contract. If you're not having any consideration, there's no question of contract. So section 25, consideration. Then how should be the consideration? Consideration should be lawful. So legality of the object and lawful consideration. Legality of the object and lawful consideration. This is entirely discussed under section 24. If you remember section 24, sorry, section 23, section 23 and section 24. Section 23, mainly section 23. Section 23 totally tells us, very nice. Section 23 totally tells us, when will you say the object is lawful? When will you say the object is legal? Right. So that is legality of the object and lawful consideration. Section 23, section 25 is consideration. Section 23 is legality of the object and lawful consideration. Of course, section 24 is related to that only. Section 24 is related. Then comes sixth thing, that is not expressly declared as void. Not expressly declared as void. We have a cluster of sections here, right? 24 comes, 26 comes, 27 comes, 28 comes, 29 comes, and 30 comes. Of course, there are other sections also where it is expressly declared as void, but important sections are 24, 26, 27, 28, and 29 and 30. So till here, up to section 30, we have various topics that deals with the formation of contract, how to form the contract. All these things are discussed in these sections. Very important, sir. Everybody should be remembering this particular chart that I have given here. If you recall this, if you on a daily basis, if you keep on recalling till you write your examination on a daily basis, if you recall this, half of your contract act is done. That means whatever questions comes in the contract act, half of the questions comes from these sections. This is one cluster. The other cluster is performance part, performance breach, and quasi contract and contingent contract. So simple, sir. Even though we have so many number of pages, once we condense the discussion, once we shorten the discussion, once we remember less things becomes easier to recall. So what we are doing now through this particular marathon session, through these sessions, is that we are simplifying the concepts. We are reducing it to such an extent that we can sit at a place and we can keep on recalling. Even though I took around 15 minutes to reach this particular area, if at your individual level, when you sit and recall this, it will not take more than 10 minutes to reach this particular area. That means up to section 30, a quick recap happens. So please make sure you do this on a regular basis. Any subject you may take, along with that subject, you make sure that you sit and recall the provisions of the law like this. You need not open the books. You just have to sit and recall. Yes, that exercise is what we are doing here. So of course, these are the possible things under section 10. Now going on detailing the parts. I should go for something called as offer. Offer definition is already set for us. When a person signifies his willingness to do or abstain from doing anything with a view of obtaining the assent of the other party, is said to have made an offer. Now, in offer, what are the important areas? What are the important areas when it comes to offer? So we have discussed one case law there, Balfour versus Balfour. After that, no other case laws are important there. Next important thing is I'll go for, before I get into this particular definition part, before I go for offer part, there's one small part to understand. There are types of contracts. In types of contracts, what and all important, sir? Sometimes they'll ask you, they'll give some examples and they'll ask you to determine what type of contract is it. Now, the other day I was seeing some of our students had shared a meme. He just gave a meme in the Insta saying that you cannot determine the difference between valid contract, voidable contract, and void ab initio. He had put that Bisleri will say that particular thing will come. But my proteins will never say that. Yes or no? My proteins will never say that there is a difference. Sorry, there is difficulty in identifying the difference because we have made it very, very clear for us. So valid, void ab initio, and void contract, void agreement and void contract. We are very clear with this. So let me recap what exactly it means. Valid contract. What do you mean by valid contract? When all the essential elements under section 10 are there in a particular agreement, I'll consider it as valid contract. It will be considered as valid contract. I recall. What is it? When all the essential elements are there, it is called as valid contract. If any of the essential element is not there, it is called as void agreement. We consider it as void agreement. Suppose if all the essential elements are there initially when the contract is entered, later on what happens? Later on, any one of the element goes on missing, possibility of performance, maybe the party dies or something, I'll consider it as void contract. That means initially it was valid, later on it becomes. Now void agreement is nothing but void ab initio, something that is void right from the beginning. Yes or no? Yes, my dears. Are you all getting it? Are you all understanding? Are you in a position to recall it? Please give me a response in the chat box. Yes. So this is with respect to validity of the contract. These three sections are very important. Valid contract, void agreement, void contract. Voidable is very simple. Where contract is enforceable at option of one party but not at the option of other party, I'll consider it as voidable. Able means what? Party is in a position to cancel it out. Party has a capacity to cancel it out. He is having the right to make it void or valid. This is what is called as voidable. Section 2 clause I. Yes. So this is important here. Definitions of valid contract. Definition of void contract. Void agreement, I'll write first. Void agreement. Definition of void contract. And last one is voidable contract. Very, very important definitions. These many definitions are important. Yes. Make sure that you recall them also when you read. So valid contract, simple one, section 2 clause H only. Section 2 clause H. Agreement enforceable by law is called as valid contract. Void agreement, 2 clause G. Void contract, 2 clause J. Last one, voidable, 2 clause I. So these are the things to be kept in mind. Yes, my dears. So moving on further, we have offer or proposal. Offer or proposal. What are the concepts to be kept in mind with respect to offer or proposal? General offer. Very important thing to be kept in mind with respect to general offer. Case law. Which case law, sir? Which case law? General offer. When it comes to general offer, we have a very important case law. Which is that? Can you recall the name of the case? That's very nice. The name of the case is Carlyle versus Carbolic Smoke Wall Company. Any person who has the knowledge of the offer can give the acceptance. Very nice. Any person who has the knowledge of the offer can give the acceptance. That is what is discussed in Cargill versus Carbolic Smoke Ball Company. There can be an easy question here, sir. An advertisement is put saying that if you fulfill these many conditions, this will be given to you. If that type of question comes, you should easily relate it to general offer. At the same time, specific offer, when the offer is made to a particular person or particular group of person, we'll consider it as specific offer, and specific offer can be accepted only by person to whom the offer is made, offeree, correct? That is specific offer. So very important factors here to be kept in mind: Carlyle versus Carbolic Smoke Ball Company and specific offer. We can expect a question here also, very important. Make sure that you are 100% clear about these concepts. Yes, general offer, specific offer. Offer to specific person. Offer to specific person or group of persons. Offer to specific person or group of persons is called as specific offer. Offer made in general to public is general offer. Very nice. Now, when it comes to essentials of valid offer, what are the things to be kept in mind with respect to essentials of valid offer? See, specific offer, you can also keep in mind the case law, Bolton versus Jones, correct? Bolton versus, of course, we learn it in acceptance, but it's also for Bolton versus Jones. It can also be quoted for specific offer, Bolton versus Jones. Supply, so for supplying the goods where there is an offer, the person to whom the offer is made can give the acceptance. No other person. Very nice. Bolton versus Jones. Very nice. Next, when it comes to essentials of valid contract, important essentials, which are they? First one is communication of offer is important. Communication of offer. Communication of offer. If the offer is not communicated to the other party, it will not amount to valid offer. Communication of offer is important. Sir, which case law, sir? Communication of offer. Without communicating the offer, acceptance cannot be given. Which case law? Or acceptance cannot precede offer. Before the offer comes, you cannot give the acceptance. Which case law, sir? If you can recall. Yes, my dears. Which case law? A person's nephew goes on missing. His servant will be sent to find the nephew. Later on, the person makes a declaration saying that any person finds my nephew will be rewarded with some amount. And then the servant comes with the nephew. When he asks for the reward, the person says, I never made an offer to you. And even in the court says, acceptance cannot precede the offer. The classic case law that we have to see is Lalman Shukla. Lalman Shukla versus Gauri Dutt. Very nice. Very nice. Lalman Shukla versus Gauri Dutt. Very, very nice. I can see lot of students responding. So I feel this session, you people are making use of the session in the maximum possible way, best possible way. It is very nice to see you people so energetic early in the morning, participating in the live sessions. Number of students are increasing. Very nice. So it is also good to see you people are recalling along with me, and you people are like revising the things that you know. So this is really nice. This is really nice, and I appreciate your participation. You're all enthusiastic to get your CA foundation cleared, and I hope that all your dreams will come true. To participate, revise, recall, definitely you will clear your examinations. Yes, moving on further. Communication of offer, Lalman Shukla versus Gauri Dutt is over. Very important case law to be kept in mind. Next, there is one more important point which we tend to forget, or we tend to ignore. That is, offer can contain any term. Offer can contain any term any condition, but offer cannot contain a term, non-compliance of which would amount to acceptance. Offer cannot contain a term, non-compliance of which amounts to acceptance. Can you recall the case law, sir? Offer cannot contain a term, non-compliance of which would amount to acceptance. Can you recall a case law there, which we can relate to that particular topic? That means you're saying offer should not have a term. If you don't accept the offer within such and such date, I'll consider it as accepted. You cannot put this type of condition. Again, a horse case. You remember the horse case? Which horse, sir? What is the case law? Where one person sends an offer letter. If I do not hear from you within a week, I'll consider the white horse as mine. Is that, sir? Can you recall? Everybody. So it is related to horse. Horse is in the house. So name of the case is very nice. Felt house versus Bindley. Felt house versus Bindley. Felt house versus Bindley. Of course, we write this in the acceptance part. Same case law is applicable here also. Felt house versus Bindley. Very nice. Very nice. Omkar, Mahidara, Anil, Abhilash. Many people are responding. And we also have the star of Tulunad itself. Tulunada Porlu Avinash. Very nice. Such a nice name he has kept for his YouTube channel. Yeah, Rajeshwari. Good to see you all live. Yes, Sahana is there. Yes, sir. Shall we proceed? Offer cannot contain a term, non-compliance of which would amount to acceptance. So these are the two important elements where we can expect questions. Of course, other essential elements are also there, sir. What I'm saying, examination perspective, when you see it from the examination perspective, I feel these are the two important areas where there can be a question. The third important area is comparison between offer versus invitation to offer. Offer versus invitation to offer, we can expect questions. Offer versus invitation to offer, we can expect some questions. Shambhu Dayal, if you remember the case, questions. Shambhu Dayal has some supermarket, they say. Correct? A person goes and picks up the goods in the supermarket and goes to the cashier. Cashier denies to sell it. Whether the party can compel the seller or supermarket owner to sell the particular goods. Normally, this question is expected. So your answer will be offer is different from invitation to offer. In case of invitation to offer, what happens? The person making the invitation reserves the right to either accept the offer or reject the offer. Very important. One more case law we say there. Which is that? Harvey versus Fissy. Bumper hall pen. See, two important case laws are there here. One is Harvey versus Fissy. The other one is Harris versus Nickerson. In case of Harris versus Nickerson, the what do we say? Auction sale, advertisement of auction sale comes into picture. I hope you remember this also. There is an advertisement for auction sale. The person travels down and finds that the auction is cancelled. Later on, he claims the person who has put the advertisement responsible for the loss. But court says mere invitation to offer is not an offer. Same thing happens here also. Harris versus Nickerson. These are the important areas to be kept in mind with respect to difference between offer and invitation to offer. Offer and invitation to offer. Important area. You can't miss out this also. So if these are the topics to be kept in mind with respect to offer, next comes your acceptance. Definition of acceptance we have already discussed. What is it? When the person to whom the offer is made signifies his willingness thereto, signifies his assent thereto, the offer is said to be accepted. Proposal when accepted becomes promise. Proposal when accepted becomes promise. Essentials of valid acceptance. Now, before I go for essentials of valid acceptance, there can be a theory-based question. Theory-based question asking you to elaborate the particular statement by Sir William Anson. What did Sir William Anson say? William Anson said that acceptance is to offer what a lighted match is to a train full of gunpowder. Right? The same can be expected in the examination asking you to elaborate. So there you will have to have some points. You should say, once the offer is accepted, it cannot be retracted. Offer can be revoked before it is accepted, just like how lighted matchstick can be avoided to be dropped out on the particular, what we say as a train full of gunpowder. But once it is done, you cannot stop the explosion from happening. You cannot stop the explosion from happening. So these are the factors to be kept in mind with respect to that particular statement. So that statement is important. Acceptance is to offer what lighted match is to a train full of gunpowder. This is important. This is important. Remembering these provisions are important. Moving on further, what we have? We have legal rules of valid acceptance. What are the legal rules of valid acceptance? So going to legal rules of valid acceptance. There, what is important? Who can give the acceptance? Who can give the acceptance? So person by whom acceptance can be given. Again, there is a case law. Already we have seen the case law here. If you see Bolton versus Jones, I have written it for specific offer. Same case law will come here also. Same case law. Bolton versus Jones. Only person to whom the offer is made can give the acceptance. Same case law will be applicable here also. Same case law. Bolton versus Jones. Sir, important point. You can expect a question in this area. Very, very important point. Next is second possibility. Acceptance must be absolute. Nail versus merit. Nail versus merit. Nail versus merit is important. You can expect a question. Similar question. So nail versus merit is important here. Acceptance must be absolute. If you put a condition for the acceptance, what happens? It amounts to counter offer. Correct? And next important factor to be observed is acceptance must be communicated. Acceptance must be communicated. Communication of acceptance is important. So for communication of acceptance, we have a case law. Which case law, sir? Brogdon versus Metropolitan Railway Company. Brogdon versus Metropolitan Railway Company. Very important with respect to acceptance. Communication of acceptance. How to go with the communication of acceptance. Very important. Now, see, there is one more possibility of a question, which you have already seen in ICA material also. That principals, example, where they say a person applied for the post of principal. Management decided to appoint such person, but the same was not communicated. But one of his relative, who is either a teacher in the school or one of the member of the management, conveys it to him privately. But later on, some other person comes and occupies the position of principal. Can the person sue? Normally they ask a question. Can the person sue? So remember here the answer is communication of acceptance is not done. So two important provision. One, acceptance must be communicated. And second important thing is acceptance must be given by the person to whom the offer is made. Both the provisions you can utilize for answering the question. Both the provisions can be utilized. You can answer it based on both the provisions. So important factor to be observed. Yes. So these are the three important points which we can expect here. And one more thing is mere silence is not acceptance. Last one, mere silence is not acceptance. Again, Feldhaus versus Bindley. Feldhaus versus Bindley. This case law can be relied. And one more thing is principal question. Principal question, whatever is there in ICA material, you should pay attention to that also. So these are the things to be kept in mind with respect to acceptance. Simple parts, yet very, very important where you can expect some examination questions. I hope it is clear to us, everybody. Shall we proceed? Shall we proceed to the next topic to be discussed? Communication of offer, communication of acceptance. One more important area to be discussed. Communication of offer, communication of acceptance. Section 4 speaks about communication of offer, communication of acceptance, and section 4 simply says, when will you say the offer is communicated? If this question is asked for theory, how much is to be written? Which question, sir? Can you please repeat which area you are asking? Can you be very specific here? Which question? Okay. The problem is like I speak here and then it gets telecasted to you. So bit delay. There will be some amount of delay. So once you reply back, I'll respond to your question. Once you reply back in the chat box, I'll respond to your question. So yeah, going by this next provision that I have to cover, next thing that I need to understand is section 4 communication. Communication of offer, communication of acceptance. Very important thing to be kept in mind here is what is the time period? Acceptance 1. Okay, acceptance 1. If a question comes, if it is the question on essential rules of valid acceptance, all points in the institute material, all the points in the institute material should be written. All the points. We have around 6 points, essential elements of valid acceptance, 6 or 9, A, B, C, D, E, F, G, 6 points, yeah. 6 points are there. All the points should be written. All the points. Shall we? Communication of offer, communication of acceptance. Communication. So, communicating means conveying it from one person to another person. Very important thing here is rules regarding communication. When to communicate, how to communicate. Very important. Normally, the rules comes into picture when the offer or acceptance is made over telephone. Sorry, post. Telephone is simple, sir. It happens at the moment only. But important thing is when it is made over post. When you are sending the letter of offer through post. When will you say the offer is communicated, acceptance is communicated? Very important. So, for offer, only one angle. Offer, when it comes to the knowledge of offeree. When it comes to the knowledge of offeree. For acceptance, we have to divide it into two categories. As against the offerer, when acceptance is put in the course of transmission, when acceptance is put in the course of transmission, you can respond along with me. Acceptance with respect to offerer when an acceptance is put in the course of transmission. Similarly, with respect to acceptor, acceptance is complete as against the acceptor. When, sir? When it comes to the knowledge of offerer. When it comes to the knowledge of offerer. Important rules, you should keep them in mind. Section 4, these are the important points in section 4. So, possible questions. One of the possible question here is, letter of acceptance, if it does not reach the offerer, should the offer be performed? When the letter of acceptance does not reach the offerer, should the offer be performed? Should the contract be performed? You have to go by rule number 1. Acceptance rule number 1. It says, the moment it is put in the course of transmission, it will amount to acceptance. Communication is complete. That is what it says. Having been said that, even if the post is not reached, or even if post does not get reached to the offerer, even if the post is lost in transit, in all those circumstances, offerer will be bound to perform. Very important point to be observed. Even if the letter of offer does not reaches the offerer, still the offer must be performed. Because acceptance rules says it. So that is why this can be a possible question. Please make sure that you have understood this also. Please make sure that you give your right answer here also. Coming to section 5, revocation. When can you revoke the offer? When can you revoke the acceptance? Revocation of offer, revocation of acceptance. Communication is very simple. Communication of revocation. Whenever any party, it may be offerer, it may be acceptor, whenever he puts the letter of revocation in transmission, it is put in the transmission, as against him it is complete. As against the person revoking it, it is complete. When the other person receives it, or when it comes to the knowledge of the other person, revocation is complete as against the other person. That is the person opposite to the person who is making the revocation. So if the offerer is revoking the offer, the moment he puts the letter in transmission, the moment he puts the revocation in transmission, revocation is complete on his part. As against the acceptor, revocation is complete when it comes to the knowledge of acceptor. This is with respect to communication part. Moving on further, when can you revoke? That is important under section 5. Time period for revocation. Offer and acceptance. Offer can be revoked anytime before communication of acceptance is complete. As against offerer. See, cross multiplication. This point is related to this. This point is related to this first point here. Communication of acceptance and revocation. We are discussing about revocation. Revocation of acceptance. Anytime before communication of acceptance is complete as against acceptor. So this particular point is related to this second one. This is related to the second one. Very specific points. You should be clearly understanding them and answering the question. Section 4, Section 5. One more possible area is standard form, special forms. Standard form, special forms. What exactly we can expect as questions? We have a classic case law, which is that Lily White versus Manuswamy. In Lily White versus Manuswamy, what happens? The condition that the launderer will be responsible only for 15% of the loss is communicated tacitly. Tacit means through silence. If you do something to bring it to the notice of the acceptor, if you do something, either putting it in the notice board or writing it overleaf, writing it in the receipt, or mentioning the name of the website where the particular terms and conditions are found. If you do something to bring the special terms and conditions to the notice of the acceptor, it is considered as valid communication of special conditions. There is no need of expressly conveying the conditions. Expressly, you need not state the conditions. But only thing the court says is the conditions should be reasonable. Unreasonable conditions are not valid. The conditions should be reasonable. Sir, one more possible question is there here. There is a possibility of one question. What is that? They may ask, say, you go to a lodge. You are booking a lodge room. After you enter the room and as you close the door, over the door, there will be some conditions, terms and conditions, which you are subjected to for using the room. Can you consider it as valid communication of special conditions? Can you consider it as valid communication of special conditions? Now see, it is very clear that special terms and conditions should be conveyed at the time of entering the contract, not at the time later. After the contract is entered, if you impose any special terms and conditions, it will not be a valid contract. That is why you should keep in mind that special terms and conditions are to be conveyed or communicated at the time when the contract is finalized, when the contract is entered. Very important thing you should observe. So that can be also a possible question. So communication after acceptance is not valid. So with this, we conclude the important provisions from unit number 1. Contract Act unit number 1. These are the important provisions which every student must know before he goes for the examination. If at all questions are framed, it should be based on this. Of course, theory-based questions can be found, like mode of revocation of offer can be a theory question. And the in acceptance part we have discussed it. Essential elements can also be asked as theory question. Sometimes differences. See, one more important observations. I always say that students should never ignore differences. Differences should be mandatorily practiced because at least 1 or 2 differences institute will ask. And there is no difficulty in writing the answers for differences because already things are available clearly on the institute material. If you write the same thing, it will be more than sufficient. It is just that you should be writing clear points. So there it is like you write 1, 2, 3, 4 point, you will get 1, 2, 3, 4 marks. So that is why it becomes very important. And answering techniques are already known to you. Now, by now, you people might have been practicing n number of times how to answer the questions. So answering is not a difficult job for you people because we have this particular division, right? When it comes to case-based answers, we have this division where we say provision, analysis, conclusion. Provision, analysis, conclusion. The first and foremost important should be given for the provision part. In the provision part, you should be very specific about which provision are you answering. If you know the section number, quote the section number. If you do not remember the section number, see now that you are almost about to write your examination. So at this time, probably some may feel, sir, we don't remember any section number, what to do? See, I'll not say this is the right thing to do, but this can be a saver for you. At least if at all you're not getting the marks, but you're not going to lose out the marks. Very sure. You have to keep in mind that you can simply write as per the provisions of Indian Contract Act. If the question is based on Indian Contract Act, you can simply write as per the provisions of Indian Contract Act, where you cannot remember the section numbers. But make sure, to the great extent, make sure that you remember the section numbers properly. You remember the section numbers properly. Make sure that. Now, next important thing is consideration. Consideration definition is given under section 2 clause D. Now, what are the important things that should be there in the definition of consideration? First one is at the desire of promiser, promisee, or any other person does or abstains, had done or abstained, promises to do, promises to abstain from doing anything. Why? Such an act, abstinence, or promise is consideration. Important definition. Important definition. You have to keep in mind. Now, legal rules, see, consideration is one such chapter where we have very limited areas. There is no unnecessary stuffs in the chapter. So there is no provision for skipping anything in this particular chapter. You have to remember each and everything. You have to remember each and everything here. So in legal rules governing valid consideration, legal rules of valid consideration, what are the things to be kept in mind? First thing is it must move at the desire of promiser. It must move at the desire of promiser. Which case law we have? Which case law? It must move at the desire of promiser. Which case law? Durga Prasad versus Baldev. Case law is important. Durga Prasad versus Baldev. Case law is important. We can expect questions here. Durga Prasad versus Baldev. Second one. It may move from promisee or any other person. It may move from promisee or any other person. Which case law do we have, sir, here? It may move. Very good, very good. Which case law do we have? It may move from promisee or any other person. The very, very famous case law where we can expect some questions also. Very nice. Which is that? Yeah. So which is the case law? Chinaya versus Ramaya. Chinaya versus Ramaya. Very nice. Chinaya versus Ramaya. You have a question in the institute material. Which is that? So Mohanlal. Question is important. Please make sure that you have completed or you have read this question also. Mohanlal case is there, no? There two factors are there. Chinnaya versus Ramaya will also come and will also have the provisions of covenant running with the land. Both are important. So you should keep in mind that also. Institute material. Institute material question is important. It may move from promisee or any other person. Important point. Next, when it comes to consideration, one more important area where there can be a question is performance of what one is legally bound to perform is not a consideration. Performance of what one is legally bound to perform is not consideration. Important. Advocate can charge fees for defending his client, but advocate cannot charge fees for only purpose of winning the case. Doctor can charge a fees for treating his patient. Doctor cannot say that if you pay me extra money, I will make the patient survive. See, it is the duty, sir. It is the duty of the doctor to see that he works in the best possible manner to protect the health of the patient. So if he is asking some extra money just for the purpose of saving the client, saving the patient, it is not a valid consideration at all, because it is his legal duty to do it. Where a person has a legal duty, that legal duty cannot be considered as a consideration. That legal duty itself cannot be considered as a consideration. Important area. These are the three important things where there can be a possibility of question when it comes to essential rules of valid consideration or legal rules of valid consideration. It should be kept in mind. Clear? Yes. Next comes an important area, section 25. Agreement without consideration is void. Section 25, agreement made without consideration is void. Important. Agreement made without consideration is void. Important area. We can expect a question. There are possibilities of questions where we have certain exceptions. Even if there is no consideration, there is a valid contract. First one we always say, which is that natural love and affection. When the agreement is made out of natural love and affection, see, when you say natural love and affection, you should keep in mind the conditions which must be followed, condition which must be fulfilled. There should be natural love and affection between parties standing in near relationship. The agreement should be made in writing and it must be registered as per applicable law. If only four conditions are satisfied, the contract will be valid. Otherwise, there is no valid contract. What and all possible questions are there, sir? Husband and wife, they enter into an agreement. Husband makes it in writing. Whether it is enforceable? Answer is yes. Now you cannot quote Balfour versus Balfour. Sir, Balfour versus Balfour means it's the oral part where you don't have the intention to create legal relationship. The moment you write it down and register it, it becomes valid. Correct? It becomes valid. That is why natural love and affection, when the agreement is made out of natural love and affection, it becomes a valid contract, provided it fulfills four conditions. Possibility of questions. Question number one, husband and wife entering into an agreement. Valid. Question number two, husband quoting frequent quarrel between husband and wife, promises to pay in writing certain sum of money to his wife, gets it registered. This is not valid because there is no natural love and affection. There should be natural love and affection. Parties must stand in near relationship. So natural love and affection is missing. Third type of question possible. Grandfather wants to gift his property to his granddaughter. He makes it in writing. He enters into an agreement. Then what happens? Then when he goes for registration, he dies because of accident. Whether it is a valid contract? No, there is no registration. All the essential elements should be completed. Only then it becomes a valid contract. So here what is missing is registering is missing. So it doesn't become a valid contract. Second, compensation. Promise to compensate for a past voluntary service. Promise to compensate for past voluntary service. So there should be a voluntary service for the benefit of the promiser. Condition number 1. And condition number 2, the promiser must promise to compensate such past voluntary service. There is no question of writing, registering and all. If these two conditions are satisfied, even if there is no consideration coming in, the contract will be valid contract. Important point. We can expect a question. Or third, promise to pay time barred debt. Now we know what is time barred debt. Limitation Act. As per Limitation Act, a suit must be initiated within 3 years from the due date when the debt becomes due. In case of failure to start any legal actions, the debt becomes time barred. The debt becomes barred by limitation. That means no action can be taken. Now, when the debtor promises to pay a time barred debt in writing, it becomes a valid contract, even if there is no consideration. Promise to pay time barred debt. All these are discussed under section 25. 25 subsection 1, 25 subsection 2, 25 subsection 3. Now, explanation to subsection 25, section 25. Explanation to section 25 says completed gift is also valid contract even if there is no consideration. Once the gift gets completed, when will the gift gets completed? Gift gets completed when it is accepted. Once the gift is accepted, later on you cannot say that there is no consideration, hence it is not a valid contract. You cannot claim this particular part. So this is fourth important case. Then 3 different cases are there. Contract of bailment. Bailment means giving your goods to someone else for some purpose, on completion of which the goods will come back to you. This is called as bailment. In case of bailment, even if there is no consideration, it becomes a valid contract. Even if there is no consideration, it becomes a valid contract. That is bailment. Sixth concept is agency. In case of agency, even if you are not paying any remuneration to the agent, still the contract of agency will be valid contract. And last one is in case of charity. Now, charity, what you have to remember? In case of charity, what you have to remember? The promisee must have incurred some expenses. That means where one party promises to compensate the other party, where one party promises to donate some amount to other party, in faith of which the other party incurs some liability or expense. The other party incurs some liability or expense. Only then this provision will come. Just because a party promises to donate something, it will not form a valid contract. Only when there is a promise. Only when there is a promise to pay and the other party has incurred some expense based on that, then it becomes a valid contract, even if there is no consideration. These are the 7 different points to be kept in mind. This can be a straightforward theory question, or we can expect a case-based question from any of these points. You have to remember this. Very important. You cannot miss out any of the points under this. Very, very important. Please make sure that you recall this also. So with this, we conclude section 25 of the Contract Act. Hello, my dears. Now, please give me a response, quick response in the chat box. We have 64 students here. Students are adding, sometimes students leave out, whatever it is. 64 students, such an energetic crowd early in the morning just to revise, recall the things. I hope you are all understanding and you are all taking out the particular benefit of this particular crash course. Yes or no? Yes. That is very nice. Very nice. See, now we have completed up to part of the unit number 2. We have completed a part of unit number 2. There's one more small part, that is doctrine of privity of contract. This doctrine of privity of contract, I'll take it up in the evening session to come. We have an evening session. In the evening session, I'll be discussing about doctrine of privity of contract, and then after that, we'll be going for unit number 3, which is going to be a very, very important discussion. I'll be sharing out very important sections there, where students will find certain areas confusing. I'll be rectifying them, I'll be clarifying them, and where students can go through those provisions and prepare for the examination. That is one point. And also performance of contract, where many students find it difficult to remember the provisions. I'll tell which are the important provisions there, which you must focus on while preparing and how to focus on. Yes. So these are the things that we are going to do in the evening session. Make sure you attend the evening session also. Make sure you inform your friends. Make sure more number of people will turn up for our session. Yes. Make sure more number of students attend. I have a doubt here. Could you please explain? Consideration need not be adequate. What questions can be asked from it? Normally, we cannot expect practical based questions there. But even if they ask, they may ask you that a particular goods worth 5 crore rupees is getting sold for 5 lakh rupees. Later on, the party says there is no adequate consideration, hence the contract is not valid. The party is denying to sell, saying that there is no adequate consideration. Whether it's a valid contract. The answer is contract is valid. Reason being, consideration need not be adequate. We don't have any provision which says that equal value of consideration should be given. It is sufficient if you have some consideration. That is what is the need. Correct? So this type of practical question they may ask. Hardly they have asked. I have not seen any much of the questions from that area, but still, even if they ask, they'll say one higher valued commodity is getting sold for some lower value. Later on, they are trying to avoid the contract, saying that there is no sufficient consideration. Can they avoid? The answer is no. They cannot avoid. Clear? Is it clear, sir? Everybody? Yes. Please make sure you attend the evening session also. Make utilization of this particular session so that you can recall n number of provisions. And this is going to be very much concentrated. There is no other diversions here. We are going to be fully focused on this particular topic. One thing, that is completing our portions and completing all the important aspects of CA foundation law. So here, this particular notes what I'm writing, the very condensed notes what I'm writing, this document will be shared once we complete today's session. After we complete today's session, evening session also, we'll be sharing this particular material so that you can utilize this particular thing, right? So for now, I'll end here. We'll meet back in the evening with the same energy and if possible with a higher energy. We'll meet back. Thank you. Take care and have a good marathon revision day for you for the other subjects to come. Thank you. Take care. Have a good day.